Well, let me know what you think about this one. And thankfully, this episode won't be released before Tuesday, so my opposing counsel won't hear about it. But my client has a felony conviction, not one, but multiple. What I intend to do in opening is to say, well, one of the reasons why we're here is because of that felony conviction, because they're not willing to give him a compensation for what was taken from his health and quality of life because he happens to have a felony conviction. And so in many ways, I'm trying to get in front of it, own it, use it as a strength versus something where I'm just responding to.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, so we're back, and we've got Irv and Joe Cantor with us. Gentlemen, we've been looking forward to this one for a while. If you wouldn't mind, please go ahead and introduce yourself.
Thanks, Sharif. I'm Joe Cantor, and I'm a partner at Cantor, Grana, Buckner & Bucci here in Richmond, mainly practicing personal injury, wrongful death, premises liability cases. We also have a company called Jury Impressions that puts on focus groups for lawyers across the state, across the country, really. We're doing them all remotely. I love what I do.
Thanks, Joe. Sir?
I'm Irv Cantor. I'm with Cantor, Grana, Buckner & Bucci also. I'm Joe's dad. I've been a trial lawyer for 45 years. It's something that I love, and it's been a lot of fun, and we appreciate you coming over today.
Yeah, well, we're really happy to have you. Sir, if you don't mind, if we start with you, how did you get into this line of work?
When I was in law school, I always wanted to be a trial lawyer. It's something that's why I went to law school. And when I got out, I had taken a job in Tampa, Florida, and at the last minute, to be a trial lawyer with a big firm. And at the last minute, I said, I don't think I want to live in Tampa. And so I took a job with the Virginia Supreme Court at the last minute, clerking. I clerked there for a year and then got out and immediately started doing trial work. And I was a criminal defense lawyer for my first 3 or 4 years.
Why a trial lawyer?
Because it's where you find justice. It's the way to find justice for people. And I believed in the system. I knew the system worked. And it was something that I felt like I could take care of the underdog and help that underdog plow through all the odds against them. And that's why I wanted to do it.
Joe, going to you went to law school. What led you to law school?
So I really had no idea what I wanted to do with my life in college. Got in a little too much trouble in college. And my parents actually kept me home for a semester to kind of figure out where my life was headed, where I wanted my life to head. And I worked here, interning with the firm that year, that semester, and I fell in love with it. Got to sit in on a trial. I was there from opening arguments till right through the end, till the verdict was reached. And it was such a cool experience, and I knew that's what I wanted to do.
I mean, I'm sure it helped that your father is a partner at the firm and one of the founding attorneys at the firm too. And you were like, you know what? You're learning from 40-some years of experience.
Well, I didn't appreciate that most of my life, and because I didn't think I wanted to do that. He told me, don't do it. There's too much stress. There's too much anxiety associated with the job. Don't do it. Get into something else that's easier on you. But it really was watching the rest of the partners with the firm, what they actually do on a daily basis, and seeing them meet with clients and prep clients and meet with family members of a loved one who had died. You know, when you see that, the personal connection, it really makes it special, and it makes you feel like good about what you do and helping people.
It's very clear that you guys really love what you do. And why is that?
To me, it combines all the things I would want in a job. I'm able to deal with people on a very personal basis. I'm able to help them at the most important thing in their life. Usually it's a very tough thing in their life. So I'm able to help them with that. I'm able to fight for them in court, which is just a blast. And I'm able to, if successful, get them justice, which just gives you so much satisfaction. And on top of that, it's the most intellectually stimulating job I can imagine, because I have to learn about science, medicine, brain injury, surgery, products liability, you name it. We have to learn it for every case. So I've never been bored. And even with all the anxiety and sleepless nights, it's been a fantastic career. I love it.
And at what point did you narrow down and say, I want to just focus on personal injury?
After 3 years of doing criminal defense work and being in court every day and going to the jail and having my clients tell me the same story over and over, I sort of made the decision, I think I want to try something different. And right about that time, a buddy of mine from college had asked me to do some insurance defense work, believe it or not. And it got me into trial. I was doing the small cases for Lloyd's of London. There was another attorney who did all the big cases. I just had the little ones. And it got me in court a lot. And I did that for about 2 or 3 years. And I ended up hating it because I identified with the plaintiffs and not the insurance company. And so as soon as that was over, as soon as I got to the point where I could give him back all his files, I switched and did plaintiff's work and never looked back. It was the best decision I ever made.
You talk about justice, and the reason why you love it is because you're pursuing justice for your clients. You can't bring their health back, but you can bring compensation. How do you determine the compensation amount that equates to justice? And I know that's a tough question, right? But that's what fuels your passion to go in the courtroom.
It's a great question. A lot of times the verdict, just getting the verdict is more important than the amount. And the verdict itself is justice for that client. Knowing that a jury agreed with him or her that it wasn't their fault. And that part of it, just the process itself brings justice. On the amount, I learned early on the only way to figure out how to settle a case, what amount to settle a case, how to try a case was to try it to a jury before the real jury, okay? And so back in the early 80s, I would drive my neighbors crazy. I would tell them, look, I got this trial. I've got a felony. And what can I do to get my guy off? And I would tell them the case, and they'd say, there's no way you can get your guy off. And then I would run my personal injury cases by them, and I'd say, what is this worth? And I did that before every case, and I'd played a lot of sports. I wasn't always real good, but I was always prepared for all the sports I played. And I treated trial law like that. And I was a tennis player. I would never go into a tennis tournament without preparing beforehand. Same with trial work. So I did focus groups. The neighborhood gatherings and the friends gatherings turned into more structured focus groups. And I started doing that in the late 80s all the way through the present day. In every case I had, I tried to a focus group first. And I would want to see what they thought the value range was. And it gave me a pretty good idea. Because we think we know what cases are worth. But unless you do focus groups, every case is different. And so you really need to see what the real jurors think about your case. So that's how we decide how to settle and what to settle for.
How important is framing? Is the lawyer's framing of the case? I mean, my thought is it's critically important, but it'd be interesting to hear how you've seen focus groups react towards basically different presentations of the same set of facts.
Framing is everything. I agree with you. And we get our framing from the focus groups. A lot of times we'll think that the theme of the case is a certain theme, and then we'll try it to the jury, and the jurors will tell us, well, we think this is more important. And you'd be surprised how often theme number one became theme number two, because the jurors told us what they liked and what they wanted to hear. And so we get our cues from the focus groups.
Over the years, are there certain things that you all have learned from focus groups that now they just become standard for how you approach a case? One thing I could think of that might be is focusing on the defense, right? At least until you've established clear liability before you shift to damages. Are there things like that you all have learned and seen time and time again that you're now implementing in every case?
Wakoli. So breaking down the amount you ask for based on the damages instruction, the various
and
categories.
Wacoli it's a Supreme Court case, right?
It's a Supreme Court case. And we started doing that in every focus group probably 2 or 3 years ago. And we quickly learned that it helps in every single case. The jurors want an explanation for why they're giving this money. I mean, they hear the evidence, they hear the arguments, but they want it broken down into easily digestible categories and explain to them, well, this is why you should award X amount of money for bodily injuries and the effect that it's going to have on their health. This is how much you should award for inconvenience, and here's why. They want to hear that in every single case.
That's interesting. Do you ever struggle with coming up with that number, right? I've always found that, well, at the end of the day, to some extent, it is arbitrary, right? So how do you justify, well, this much for inconvenience, but only this much for effect on health and quality, stuff like that, right?
The way to test that is to push the envelope to the max. So you test a very large ad damnum, larger than you think you should ask. And then you put your suggestions for each category from the damages instruction, and the jurors will tell you that's way too much. And then we will, after we hear them deliberate, we'll debrief them and say, well, what if you said it was too much? And then we start narrowing it down. Are you talking $5 million? Are you talking $4 million? And they'll tell us.
Right.
And so it's the way to test that, the way to know is test more than you think. You can always go down.
Right.
And so we've learned over the years that's the best way to test the damages.
You know what's interesting about breaking out the damages? And I do want to ask a criminal law question here in a second, so we're not ignoring Niall over here. In other states, California, for example, so I've been fortunate enough to go to a lot of these national trial lawyer conferences, and they're great. But I know in California, the jury actually is required to assign a numeric value to each damage element, whereas here in Virginia, it's just one number at the end of the day, which is interesting, right? I imagine what you all are trying to do or are doing is you're encouraging that more methodical breakdown.
Definitely. That's what the Wacoli case said. The Supreme Court in the Wacoli case said that it was proper to suggest a number for each category of the damage instruction. And the jurors tell us over and over again, they need that. They want that. And so we do exactly that. We ask them to assign a number for each element.
And do you all break down the elements? So I think if I remember, actually I was doing it before I came here because I have a jury on Tuesday. I think jury instruction 9.0 has, I want to say maybe it's 4 or 5 or 6 I forget elements, but I can break it down and maybe I get in trouble for it. Well, I shouldn't get in trouble for it, but I can break it down into 14 different elements, right? You can split the first one. Physical pain, mental anguish can be broken into 4, right? Past, future. Is that something that you all have found is effective in the focus groups?
Yes. We've done it both ways. We've taken just the 7 items on 9.00 and just get them to assign a number. We've also broken it down like you did, future and past, and pain and suffering versus, mental anguish, that type of thing. And we've tested it both ways. It usually comes out, the discussion's the same either way.
Right.
And the jurors tell us what they think about each item. Sometimes we think, for example, that the physical pain and the injury is the real big damage. And the jurors will tell us, no, it's the mental anguish. And they'll put a much larger number on mental anguish than we as lawyers would think to do. And that tells us, that guides us in our trials.
It's also been hugely important in death cases, wrongful death cases, where we've broken down the wrongful death damages instruction by category for each of the beneficiaries.
Right.
And that gets the jury to award a lot more money because they see the effect on each child, on each beneficiary individually.
We are all walking stories, right? And your client is a story. How do you get the jurors to empathize when we're talking about something that's so arbitrary? Okay, we're talking about, pain and suffering. And Sharif often says full and fair value, what was taken from your health and your life. Something so arbitrary. How do you get the jury? How do you build that bridge for them to connect and empathize with that story?
You do it in opening. In all my cases, I do it in opening statement because that's my opportunity to tell the story through my client's eyes and tell what she went through, what she suffered, and I'm not being interrupted. I'm able to tell it as a story, and I'm able to explain how it affects every element of her life, how her brain injury has caused her problems with thinking and emotion and concentration, and she's got ringing in her ears. And by the time I'm finished opening, they know they've gotten the story through my client's eyes. And attorneys need to realize opening is powerful. Opening is where you win your case.
It's interesting you say that, because I believe exactly that. I believe opening is the most powerful part of a trial. And for a plaintiff's attorney or for a prosecutor, you're putting the lens on, and you get the chance to put the lens on that you want the jurors to see the whole case through.
Correct.
And you can get ahead of issues too, right? I mean,
without a doubt. And, get ahead of issues, but at the same time, do not highlight the other side's case.
No, but the jurors tell us they don't want us to run away from the warts. So we talk about every wart in the case.
you got to own them.
Own them.
Exactly.
Put our arms around them and say, even though that is true, look what happened. It still doesn't explain away the defendant's negligence, and it still doesn't mitigate from what she suffered.
Well, let me know what you think about this one. And thankfully, this episode won't be released before Tuesday, so my opposing counsel won't hear about it. But my client has a felony conviction, not one, but multiple. What I intend to do in opening is to say, well, one of the reasons why we're here is because of that felony convictions, because they're not willing to give him a compensation for what was taken from his health and quality of life because he happens to have a felony conviction. And so in many ways, I'm trying to do that very thing, right? Just get in front of it, own it, use it as a strength versus something where I'm just responding to. So we'll see. We'll find out if it works.
My guess is that'll work. I've represented a lot of felons over the years, and that's exactly the theme that we've tested with focus groups. And as long as you are honest about it and tell the jury, yes, my client is a convicted felon, but what does that have to do with the broken leg he suffered as a result of this crash?
Irv, you touched on something that's powerful about the opening and how you tell the story through the client's eyes. I often say, if you come across as an attorney, and I've said it on this podcast, you failed. You got to come across as a teacher or someone that they can trust and relate to. You're breaking it down to the human element. You're breaking the story down to the human element that every single juror is going to find something to connect to. And what Sharif is doing on Tuesday, it's a vulnerability. It's his client's vulnerability. And who doesn't like vulnerabilities, right? Because it shows that, this guy made a mistake, but he's human. And he deserves to be treated just like all other humans. So I'm looking forward, Sharif, to hear about you winning the case on Tuesday. So no pressure.
I don't know about that. It's a GDC appeal that I inherited, and it's got as many warts as you can. It's going to be rough.
Hey,
but
you better hold them tight. Okay?
That's right. Well, we're going to have fun doing it. And actually, we're going to do everything we can for the client. We're preparing. We're treating it like it's any other jury trial. So we're doing right. But the reality is we don't get, and at least in the civil practice, we're not getting in front of juries that often. And so another benefit of me having this opportunity is I get to do voir dire again. I get to do an opening statement again in a civil PI case, which frankly just doesn't, I've got, I think I have 3 or 4 scheduled for this next year. I can't imagine all of them will go, right? So take those opportunities when you can. One thing that I'd love to get your thoughts on is, at least I've found in personal injury cases, one of the biggest hurdles we have to jump through as a plaintiff's attorney is convincing the jury, not explicitly, but implicitly, that the reason why we're in this courtroom is not because of us. It's because of the other side. I've found in the couple years I've been doing this work that when you see a big result, a big verdict, yes, you're seeing big injury. That goes without question. But you're also seeing egregious conduct by the defendant or a very poor defense strategy. I'll give you an example. In Texas, it was last year or the year before, there was an elderly lady who was murdered by, I think it was a Charter Communications employee. The Charter Communications employee was at her house doing some work, and he killed her. He had a significant record. I think the jury came back with like a $200-some million compensatory verdict and like a $7 billion punitive verdict. Who am I to say that a life isn't worth that? It very well could be, but we're not seeing $200 million plus verdicts for any given wrongful death, right? I mean, you're lucky sometimes to get $1 million. I believe the jury came back in that case, and I've seen it time and again with such a high verdict because of the defendant's conduct. Talking about contrib, especially in Virginia, I've started to call it the poisonous fruit. And the reason why I call it that is because, yes, if the jury comes back with 1% of negligence that was the proximate cause, then we're barred from recovery. So I've found that sometimes defense strategies will be so aggressive when it comes to pursuing that 1% that they will lose credibility in the process. Have you all found that as well?
Absolutely.
So in many ways, I kind of like contrib in some respects, but I also...
I would never trade it for joint and several liability.
That's right.
Never. And we've got joint and several liability here. So the states that do comparative negligence, they don't have true joint and several liability. So I'm fine with contrib, and I agree with you. I think defense attorneys can go overboard. I've lost plenty of cases on contrib, and I've had plenty of cases where my client was negligent and partially negligent, and I lost. But that's part of the game and part of the rules, and I can live with that. I think it's fine. Jurors are wise and they are fair, and they usually can see who was at fault. And even with the contrib argument, they usually do the right thing. That's what we see in our focus groups.
And you can use it to polarize a case, right?
Absolutely.
So in the focus groups, I believe, Joe, you've told me at one point that you guys have done criminal focus groups.
Yes.
We have.
Can you talk about that?
We've done probably over the years 10 criminal focus groups, capital murders. We've done some white-collar crime, big white-collar crime in Virginia, D.C., Maryland. And the focus groups work better in criminal cases than they do civil cases. And the reason is, in a criminal case, it's easier to explain to the jury what their role is. It's either you're guilty or you're not guilty. And in civil cases, they're deciding all kinds of damages. They've got to decide liability and damages, and a lot of times causation. In a criminal case, it's just guilty or not guilty. So the focus group format with the group dynamics that we use, a lot of our focus groups, works extremely well with criminal cases. And I love doing criminal cases because they're fun, they're different, and the jurors give great intel to my clients. I've only done defense work. I haven't done them for the prosecutor's office, but the defense cases I've done have been a majority acquittal.
I'm going to be calling Joe for a jury that I got coming up in a few weeks.
Just borrow the Henrico County credit card.
So
I actually would like to do one for the prosecution. I think that would be a blast.
I think it would be a lot of fun too. And
Can we make that happen?
Of course we can.
No, in all seriousness.
And we will as soon as we get off this podcast, this recording. So transitioning from the 80s, we're talking about talking to neighbors and talking to friends, to focus groups. Telling me the similarities for those who are going to say, you know what, I'll just get a group of my friends and, hey, present my case to them, to a focus group in a controlled environment. Tell me the similarities and the differences.
The biggest thing is group dynamics. The real jury has group dynamics when they go back in the deliberation room. They have leaders and they have followers. And we see that all the time in focus group juries is they have leaders and they have followers too. And someone will put down that they find for the defense initially, because we get them to give us their individual responses before they're broken off into separate groups. And you watch them be flipped over the course of deliberations from defense to plaintiff, and they won't even tell the group that they initially voted for the defense. We see that all the time.
And Irv, how do you find your leader? Are you looking for a leader? Are you looking for someone to lead the jury?
No, not when I'm doing my focus group. When I'm doing my trial, I do.
Your trial, yes. How are you looking for your leader?
Well, focus groups are not great at telling you who the leader's going to be. I've done 700 focus groups in my career, and I can tell you they don't tell you who the leader's going to be. It's hard to pick out who's going to be that leader. You can do it a lot of times based on instinct. And I've found the leader in some trials, and I've made mistakes in others. I try to talk to that person. I try to do a lot of eye contact, especially in rebuttal closing, because I want that person to have my arguments when the folks that are against me are arguing. I want that person to champion my arguments. And so it is, as a trial lawyer, it would be great to know who the leader is. You don't always pick the right one.
Yeah, you speak in our language. Closing argument's not about giving some great summation, right? It's about arming the jurors on your side with the evidence they need to go back and argue in the real closing argument in the deliberation room, right?
Exactly.
This is good stuff.
It is good stuff. And so we often talk about that. And it's hard for us to really appreciate each juror's role in the panel. We often see a nod. And when we see that nod, we start feeding into it. And we're like, is he the one that's actually going to be fighting for me in the back? I call my jurors. After each jury. And
I do too.
And I talk to them, and for the ones that want to talk to me. And they not all want to talk to a prosecutor, but those that do want to talk to me, they teach me a thing or two. Absolutely. And they tell me either, now you were a bit too aggressive on this point, or you were not aggressive enough on this point. And then we adapt to it. But you're exactly right. We're giving them the artillery.
Yep.
To go in there and go to war for you.
There's something that been working on, because I'm a control freak, and I think many of us probably are who do this type of work. But there's a level of letting go that I think is important when you're talking to the jury. We have to trust you. And at the end of the day, I do trust you, and I trust that you're going to do the right thing by my client and by the defense. And I think that's, in many respects, an incredibly important part of trying cases. And it's somewhat counterintuitive to how we're taught, because we've got our points, we've got our arguments. I did the 3-week Jerry Spence course this summer, and I remember them saying, if you are arguing, you're losing. It's about telling a story that connects and about trusting that the jury will connect with that story and then do right by your client. What are your guys' thoughts on letting go, I guess, in some respects?
Well, I can tell you from after 45 years of law practice and seeing so many focus groups, so I see so many juries, I have total faith in the jury system. It absolutely works. And I don't like to hear complaints, oh, the result was crazy. The results are not crazy. The juries are usually right, and they're usually just. And so I'm very comfortable letting go. And I've lost plenty of cases. I know what it feels like to lose, and that's okay. And when I've lost those cases, I probably should have lost those cases. You know, I had tough cases, and but I have all the faith in the world in the jury system. And the more I do it, the more faith I have.
I echo that sentiment.
So about opportunities to try cases, if you're talking to a young lawyer who says, sir, I want to model your career. I want to be a trial lawyer. I want to be a personal injury trial lawyer. What are you telling them to do? I just think it's hard right now to get that experience.
It is so hard. I mean, at this point in my last 20 years of my career, it's been hard for me to get trials. I'll set 15 cases for trial in a year, and 14 will settle because we're ready, we're prepared. The other side knows we're prepared, and they make us offers that we can't refuse. So it's a huge problem. So my advice to young lawyers, and what I've told Joseph, is don't be afraid to take general district court cases. Don't be afraid to try the small case. When you've got a case where you know you're going to not get a full offer, just prepare it for trial. Just get it ready for trial. The other thing, and even that only brings handful of trials a year. And so if you really want to get experience, I'm a big believer doing criminal defense work was fantastic for me. 3 years of it wasn't enough, but I was in court every day. And doing the other side of it, doing the insurance defense, got me in court a lot. Early in my career, I was lucky. I was in court all the time. Now, I'm not. The older I got and the more successful I got, the less I was in court.
So the first 20 years of trials and success has led to the 20 years of settlements and offers that you can't say no to.
That's exactly right. Which is why I love the jury impressions business, because I get to see, I try to do 2 to 3 focus groups a month. So I'm seeing tons of jurors. And even though they're not in trials, it's just like a trial. And so it allows me to interact with the juries. It's a real passion. I love it. It's a lot of fun.
And same goes for me too, because I am a young trial lawyer and I haven't had a lot of trials. Most of my cases settle. I'm also with this firm where most of the cases settle. So it is hard to get into trial, and having the focus groups is just so valuable for me. I know that most young lawyers aren't going to have that opportunity, but it really is seeing behind the curtain, seeing a totally different perspective of trial work.
Joe, we're always looking for great attorneys, and we need some great prosecutors to judge. We may not be able to pay you what you're making, but you're always welcome. All right? And I'll tell you, Sharif knows, and I was talking to him yesterday. I was like, I got 3 juries, multiple days, all set in February, back to back to back. And I was like, Sharif, how can I prepare the way I want to prepare for each jury? One is 4 days, and 2 of them are 3 days.
And that can be an issue too,
That's
right?
hard.
It's stressful, but not only that, I question whether it's effective, right? I went out, I mean, I'm not on my own, but I more or less have somewhat of a solo practice, but I'm a part of a good firm that does cost sharing. And when I started, I was like, I'll take whatever comes in the door because I got to put food on the table. And now I'm starting to realize that by being in court every day, while it can be fun, it can be exhilarating, I think sometimes you can do a disservice to your client because you're not as prepared. In my perfect world, I'd like to have a jury trial courtroom. That would be amazing. Now, I don't know if that would ever happen. But talking about preparation, when you guys are getting ready for a trial, if you could say, all right, we spend 30% of the time on this, 20% of the time on this, what is your breakdown?
It's a good question. We're preparation nuts. We're detail nuts. I can't imagine there's too many firms that prepare cases more thoroughly than we do. It goes for every lawyer here. So we've got the entire case prepared before trial. We've got the entire cross pretty much mapped out. We've got everything we're going to cross the experts on and the defendant on. We spend so much time preparing for our cases. By the time the trial comes, we can't wait for it to start because preparation, as you guys know, it's hard, it's strenuous, it's anxiety producing. But I don't know any other way of doing it. It's just, like I say, it's just like a tennis tournament. When I used to go in a tennis tournament, I wasn't very good, but I could beat a lot of people that were better than me because I was ready. I was prepared. Same with trials.
You're competitive.
I'm very I don't like losing.
Sitting down with you last hour or so, that's one thing that we noticed, but old trial attorneys are very competitive. They got to be passionate. If you're not passionate about your case, then no one's going to be passionate for your case. And that's what it is.
You can feel it, right? If you don't believe your case 100%, then why should the jury believe you?
Without a doubt. So, Joe, talking about your dad's passion and your dad's 45 years of experience. One day you're going to sit down with your daughter or your son, and you're going to talk about their grandfather.
Well, listen to this podcast.
And make them listen to this podcast. What is something that you've seen from your father that you're trying to mirror? And because we all learn from those that have done it for much longer than we have. What is it?
I think it's his creativity. I've seen a lot of other trial lawyers, they have their book of how they're going to do things and they stick to it. And it's the same thing over and over. Every case they work up basically the same, but he's very creative about how he works up a case and how he presents the case at trial and pursuing different defendants, different causes of action that other lawyers might just gloss over. That's what I want to emulate.
You build a connection with your clients, a true connection that lives on after the money's transferred into their account. Is there a client as you sit here or a case as you sit here that just resonates with you?
I've had a ton of them that resonate with me. I could go on for hours. One case that meant a lot to me was, it was a daughter of a trial lawyer, famous trial lawyer. And she entrusted us with the case, my firm. And I was the attorney on the case. And she was in the Army. And she was home after being overseas. And she got hit by a Trailways bus on Interstate 64. And she had some injuries, some neck injuries and some other injuries. And the insurance company looks at it and just thinks it's a run-of-the-mill case. Well, for her, it wasn't run-of-the-mill. Her dad was a military guy. She was a military through and through. It meant she probably couldn't stay in the military. And so we did a focus group, and my theme was that. Look what's happened to Melanie. She can't do what she wants to do. And the focus group told me it's worth a ton of money. And the focus group was telling me, this is years ago, but the focus group was telling me millions of dollars. Okay. I knew it wasn't going to settle. But we had a mediation with the best mediator in the state. And the most they offered was $500,000. And I knew that wasn't going to do it. So we go to trial, and she was so honest and so tough. She wouldn't tell the jury that she had any problems. So I asked permission for the judge to call her twice, first to tell her story, and then again at the end of the case for 2 or 3 questions. And no objection from the defense. And he goes, okay. So we go to trial. She's my first witness and put on the case in chief. And then I called her as my last witness. And I said, Melanie, you're under oath. Are you in pain? Yeah, I'm in pain. Can you tell us a little bit about it? Barely told us. I said, did you get any sleep last night? No. Why not? Well, the pain in my neck just kept waking me up. And that's all I asked her. And so in closing, I told the jury, I said, you met Melanie, and you see how tough she is. You realize I had to call her and put her under oath before she'd even admit she was in pain. Well, that's a pain she lives with every day. And the focus group had told me I ought to ask for $6 million. I asked for $6 million, and the jury gave me $6 million.
That's awesome.
And so that case resonates with me because she deserved every penny. It was such a loss to her. And I told the jury, I said, she was not hurt by some shrapnel in Iran or Iraq. She was hit by a trailways bus on Interstate 64. And that case, I'll never forget that case, but I got 50 others if you want to hear from about them.
Do you think we in Virginia undervalue cases? And I asked that thinking after having gotten a comment from a friend who's in California. He told me one day, he said, Sharif, if Mark Lanier can go get $1 billion in Missouri, you guys can get money in Virginia. You're right next to D.C. That you are not the truth South conservative. If Satch Oliver can get a $75 million verdict in Western Arkansas, you can do it in Chesterfield County, right? Do you think that we just as a plaintiff's bar aren't asking for enough?
Absolutely. You hit the nail on the head. That's what these focus groups, and Lord knows I'm the guiltiest of all. Until I do a focus group, I might think the case is worth a third of what it really is. And then the focus group opens my eyes. That's why we won't try a case or settle a case until we've done 1, 2, 3 focus groups, because we do undervalue them. Just in the last 3 years, we've done focus groups for a $47.5 million settlement in Virginia, a $12 million settlement, a couple 15s. And the attorneys were great lawyers on all those cases, and they knew they were big cases, but the focus groups helped them realize what amount to settle for.
Well, they're good lawyers because they're coming and doing focus groups, right?
They were good lawyers way before they did.
Well, yeah, because a good trial lawyer is always trying to grow, is always trying to learn. And the fact that these people are willing to say, you know what, there's more to learn about this case. I don't just know it because I've been doing it for 30, 40 years. I think it's huge. And
Yes.
it's a benefit to their client.
Absolutely. And the way you had asked, how did you go from just talking to your neighbors to focus groups? Well, I realized if you don't do them right, the focus groups can be a hindrance. Shit in, shit out. And so I very early on said, I got to control everything. I've got to control all the variables. I've got to make sure that the jury, if I'm doing group dynamics, has clean group dynamics, just like the real jury. I only do plaintiffs' cases. And so when we put them on, I try the hardest defense you can imagine. My defense is at least as hard as the real defense is going to be. And I do that on purpose, because if I don't do that, I'm doing the focus group the wrong way. And so we changed that in the late 80s, 90s. We've perfected it over the years, and we do an extremely controlled focus group. And unless you do it right, you could have false security from the results. And so unless you know how to do a focus group, you're playing with fire. It was a huge deal for us to figure out how to do focus groups, control everything. And that's what we do. I mean, we've got a lot of controls in our system.
Can you talk about your opinion on whether to share the results of the focus group with a mediator, with the other side?
That's a great question. Our firm doesn't share. And the reason we don't share is because they know we do it in every case. And I can't tell them only about the good focus groups when I've got a lot of bad ones.
Oh, I get it. Yep.
So I don't.
Makes sense.
So we don't tell them. But a lot of my clients, a lot of the law firms that hire us do tell them. And I always warn them, look, be careful, because this is proprietary studies that you paid for and did with your work effort and your creativity. And every time you share a video clip, every time you share anything, you're giving intel to the other side. And the insurance defense attorneys are really good lawyers, smart, and they can take that and they can hurt you with it sometimes.
Are they running focus groups?
Yes, a lot of them are. They've called us over the years hundreds of times. I mean, every carrier's called me over the years to do them. And I guess maybe I'm too much of a plaintiff's lawyer. It's really not that. It's such a art to collaborate with plaintiffs on plaintiffs' cases that I just don't want to share that with the defense. It's something that we've built over the years, and it's such an art that I don't ever want the defense to get our art.
Right.
But they do tons of focus groups.
I learned the other day that a big insurance company has a program where they get staff people together in a room. You get called for your time to evaluate a case, and they basically do focus groups of just their staff people in their office.
It makes sense.
It's interesting.
The insurance companies are all about evaluating risk, assessing risk, right? So why wouldn't they? In many ways, I think at some point, if you're not doing a focus group on your case, and you're foregoing some valuable information that you could otherwise have.
Well, and going back to preparation for trial, I think doing a focus group is the best preparation you can get leading up to a trial, because you have to think of every possible defense that's going to come up, every possible argument that could come up, and how you're going to handle it, and how you're going to present the case, your own case, in front of the jury. So I think prepping for the focus group helps you in preparation for trial, and it also gives you confidence in your case, usually going into trial.
In the cases we do, brain injury cases, med mal, products liability, we might spend $30,000 on one expert, $40,000 preparing an expert for a deposition or taking the other side's expert. And I tell people, are you kidding me? That money is so much better spent on a focus group than in taking the deposition of the defense expert when he's got 15 depositions you can get electronically. About 15 years ago in my practice, I made the decision not to take defense experts and only take them when I could get them out on a motion in limine. And other than that, I just rely on the electronic footprint that they've left all over. And it's worked well. I've spent all my money in focus groups because to me, that's worth so much more than all the discovery combined.
How early or late in your case do you use the focus groups?
It depends. We've had some huge cases where we didn't even know where to file. They were great cases, and we had to decide where to file them. So we did focus groups for venue. We did a set in a rural county and a set in Richmond. It was a Virginia case, and it was interesting. The rural jury understood liability a lot better than the urban jury, and both juries were about the same on damages. So we filed it in the rural jurisdiction because of the focus group. The companion case was filed in Richmond, and both cases settled. And they were different cases, but ours settled for $4.5 million, and the other one settled for less than $1 million. They were similar. Ours was a bigger case. But I do feel like where we filed it made a big difference. So sometimes you do them early. Sometimes we had a really big case that we were handling with some law firms in Northern Virginia. Our client was a paraplegic. It was a truck case, and we had liability issues. And so we did focus groups early to figure out what our problems were, and we had some problems. Then we did them after some discovery, and it told us what we needed to do with further discovery, which helped us. Then we did another one right before trial, and it was so much better because we had taken care of problems 1 and problems 2. And so we did them 3 times and ended up, that case settled for $15 million. And I'm convinced that it was the focus groups that really helped us get to that point where they needed to settle that case, because we had followed what the jurors were telling us through each set of focus groups. But I think that it depends on the case. We do them often, and we're not afraid to do them over and over again, because sometimes we do them wrong. Even as many as I've done, sometimes you'll do them wrong and you'll put in too many variables, and the jury can't really concentrate on giving you good intel, and so we'll simplify it, take out some variables. I've made that mistake several times. But yeah, we do a lot of them, and multiple times during the case.
So, gentlemen, we've been at it for about 50 minutes or so, and I think we could keep going for a couple hours based on this conversation. But to kind of wrap things up, I wanted to ask, what does the future look like for this firm? Is retirement in the horizon, sir? Or...
I'm keeping him at work, at least in some form or fashion. I mean, he's basically a consultant at this point. He's not in trial. He's kind of working behind the scenes with me. But we have an awesome team here. We all work together on each other's cases. I'm working with Elliot on a bunch of his cases right now, Steph, Scott Bucci. So the core team is going to stay the same, and he's going to stay the same consulting.
Yeah, I mean, I'm 70 years old now, and I don't come in every day. My passion's with the jury impressions and with strategy, and I try to play tennis, golf, or something every day. So I'm trying to stay in shape now. And so the future is right here. It's with everybody but me, really.
Hey, Joe, no pressure at all, right? No pressure from your father. It's amazing that you have such great guidance. We talk about focus groups, which focuses your case. What this man is doing to your left, he's focusing the vision of this firm, and he has so much to offer. So we appreciate you so greatly.
Thank you guys both for being on this podcast. Really, really grateful. You guys took the time.
Thank you guys. This was awesome.
Really interesting.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.